As long as the ballots supposedly are mailed on Election Day, there doesn't have to be a deadline as to when they're received. Do you think that comports with a federal law that sets an election day? I don't, and 4 justices of the Supreme Court don't. We had a terrible decision from the Supreme Court this week on a case that I thought we were going to win. I thought we were going to win our lawsuit, our litigation before the Supreme Court that would that sought to uphold and vindicate Election Day by preventing the counting of late ballots. In Mississippi, they count ballots that arrive up to 5 days after Election Day. Illinois, it's 2 weeks. In California, it's 7 days after Election Day. In Washington State, it's 3 weeks after Election Day. And the federal Election Day statutes, there are 3 of them. They set this Election Day for the House, the presidency, and the Senate. And it sets an election day. And you would think that means you can't count ballots that arrive late. Well, not according to the Supreme Court majority. In a 5-4 decision, they found essentially states can set whatever day they want to be able to receive ballots past Election Day. It can be 5 days, it can be 21 days. The court set no rule. All they said is that the rule has to be more or less that the votes take place by Election Day, which makes no sense. And I'll get into the decision in a minute or two. Now, Judicial Watch had litigated this case and took the lead in litigating this case. We sued in Illinois, we sued in California, and we sued in Mississippi, which was before that specific law was before the court. It was our legal theories, it was our team that presented the argument to the court, but unfortunately, Justice Amy Coney Barrett and Chief Justice Roberts, with the 3 liberals on the court, didn't buy our argument. And I don't understand why. I look back at the argument, the oral argument, which I attended, and I remember thinking initially, Justice Barrett's questions were odd and a little bit off. I didn't quite know where she was coming from. I wasn't happy with the questions in the sense she showed sympathy for her cause. The Chief Justice was essentially silent. So I had 2 justices that I didn't know how they were going to vote. So I was a bit nervous leaving. But immediately the media thought we won. Everyone else thought we won. So I'm like, well, maybe we're going to win. And I was excited because I thought we were going to win. And I thought that the absurd position that Election Day doesn't actually mean what it says was not something that any sensible justice could sign on to. And I turned out to be wrong. So it was not a pleasant surprise to find out on, was it Tuesday or Monday? When was it? Monday. So it was on Monday. The first decision of the day on Monday was the Watson case, which is our case. And here it is. When it came down, I pulled it up quickly to see how it read. And this is what I saw immediately. The federal Election Day statutes do not prevent Mississippi from counting absentee ballots postmarked by Election Day, but received up to 5 days thereafter. Nothing in federal Election Day statutes requires ballots to be received by Election Day. It's just terrible. It undermines voter confidence. It's contrary to the plain language of the law, the practice of the states and the federal government, the understanding of what Election Day means. It's just incomprehensible that she would rule that way with the chief and the 3 liberals. And I'll go through the opinion in a little bit of detail, especially Justice Alito's powerful dissent. It was a 5-4 decision, so it wasn't like we overwhelmingly lost, although, we lost still. So, you can lose by 1 vote or 2 votes or 7 votes. It doesn't matter. You still lost. But the point being, They took a position that was outside the core of the conservative court that typically, I think, should prevail in matters such as this. And this is the statement I issued for Judicial Watch after the opinion came down. So to bring you the background up again, we sued on behalf of the Libertarian Party of Mississippi. The RNC sued as well, separately, Mississippi, over their counting ballots late. The lower court said you can't do it. They're able to do it under the Election Day laws. We appealed it to the Fifth Circuit, and the Fifth Circuit said, no, that's unlawful. You can't, the Election Day laws are what they are. You can't be counting late ballots or accepting late ballots. Then the Supreme Court took it up because Mississippi appealed that adverse ruling. So prior to Mississippi, we had also sued for Congressman Bost in Illinois over Illinois' counting of ballots that arrived for up to 14 days. Initially, the court there found that he didn't have standing, even though he was a candidate, which is kind of absurd on its face. Not kind of, it was, in my view. We appealed that to the Supreme Court, and Justice Roberts, Chief Justice Roberts, he wrote a great decision. It was a 7-2 decision, more or less, that found that candidates have almost inherent standing to sue to challenge, in this case, allegedly unlawful ballot counting. So it was a disappointment, to say the least, to see him switch sides, more or less, and say Election Day doesn't matter. So subsequent to that, we sued in Mississippi. RNC had sued. They were following our lead. They sued shortly before we did, but we were taking the lead there too. And we also had a lawsuit out in California for Congressman Issa, who was challenging California's counting ballots that arrived for up to 7 days after Election Day. And that case was on hold, but all the cases were on hold, practically speaking, waiting for the court to rule, which they did the day before their final opinions were released. And this was my response to the loss. It's a terrible decision, and I don't want to sugarcoat it. The Supreme Court's astonishing 5-4 decision further eviscerates the very notion of Election Day and threatens to make a mess, or more of a mess, for our nation's already stressed federal elections. The decision is contrary to the plain words of federal law, establishing Election Day, invites significant voter fraud, and will further undermine voter confidence in elections that could now regularly take months to resolve. Judicial Watch took the lead in trying to uphold Election Day at the Supreme Court. We remain committed to upholding the law and protecting voters from election practices that encourage fraud and chaos. As Justice Alito's dissent declares, today's decision is inconsistent with the terms of the Election Day statutes, contemporary election law principles, 2 centuries of historical practice, and the case law on the question presented. It opens up and fails to resolve a host of questions for state election officials and courts, and it creates a serious risk of further undermining public confidence in our elections and our system of self-government. Today's decision, this is me talking here, today's decision, the Supreme Court decision, ignores the plain meaning of Election Day and threatens to cause chaos in congressional and presidential elections. I would argue further chaos, actually. Congress can and should step in to correct the Supreme Court's errant decision and make clear that, at the very least, all ballots must be received by Election Day in order to be counted. So the decision itself, I think, was a bit of a mess. I didn't like the tone of Justice Barrett's dissent majority opinion. It was kind of snarky, if I'm allowed to say that. A little bit unpleasant, attacking Judicial Watch's legal arguments, because it was our legal arguments at issue here. I In the court, our lawyer made the case to the court at oral argument. We had done the historic investigations and kind of went through the precedent in a way. The RNC did a lot of work too. I'm not diminishing them, but you know, we were the heavyweight in this case in terms of the law, the history, and the legal arguments. So I'll read you a little bit of Barrett's decision, just so you know what her thinking was and the thinking of her colleagues. So this is on page 5 of the opinion. You can read the opinion its entire. You can read the opinion yourselves, but you know, I'll save you a little time. I read it so you don't have to in some respects, but I encourage you to review it. So this is one of the kickers. The federal election day statutes do not preempt Mississippi's law. The defining element of an election used in all 3 federal statutes has always been the electorate's choice of candidate. And a related federal statute, the Uniformed and Overseas Citizens Absentee Voting Act, UACAVA, that's an acronym for the ages, confirms that while federal law dictates when ballots must be cast, state law dictates when they must be received. By setting the day for the election, these statutes set the day when the electorate must make its choice. It is a fundamental canon of statutory construction that words generally should be interpreted as taking their ordinary meaning at the time Congress enacted the statute. The Election Day statutes were enacted and amended across almost 2 centuries. At all relevant times, the word election was understood to mean the act of choosing a person to fill an office, and she quotes the Webster Dictionary. And then later, I'm not going to go through all of her argument because I don't like it. If you like it, you can read it all, but I'm going to give you enough so you can understand it. Let's go down to page 9. In sum, the Election Day statutes require the electorate's choice to be made on Election Day. This occurs as long as Election Day is the deadline for individuals to vote, as it is in Mississippi. But the Election Day statutes do not set a deadline for ballot receipt, so they do not prevent Mississippi from counting ballots postmarked before Election Day, yet received afterwards. So I think that's just ignores history, and I'm going to go through and I'm going to read a lot of Justice Alito's argument because it's Judicial Watch's argument, and it's one, given the 5-4 nature of the decision, I think is going to be a persuasive historical marker for Election Day for history. She ignores the history, she ignores the precedent. We've been through all of that. I want to talk a little bit before I because I'm not going to read through the argument about this case related to this other law that she referenced, this UACAVA law. So Congress passed this law, UACAVA, that requires ballots to be sent to the military in time for the election. Same thing for overseas ballots of people who live overseas. And what Justice Barrett said, well, that law allows the states to set deadlines for receipt. And she said, well, that means the other federal Election Day law allows the states to set deadlines for receipt as well. And because states are setting deadlines for receipt in UACAVA past Election Day, it means they could do it in all circumstances. So just because there are, I guess, 15 to 30 states that count military ballots and overseas ballots that arrive late, therefore all the other states should be allowed to do that too, and the federal Election Day statutes don't matter. Well, she misread the law. UACAVA gave states the right to set earlier deadlines That was the practice. It didn't overwrite the election day laws. They didn't say, well, you can have a deadline forever. You can have no, set whatever deadline you want. The purpose of the election day statutes was to set a uniform deadline in terms of the final day the ballots must get there. So the military ballots, under this theory or understanding of the law, should get there by election day. Of course, the military can get the ballots there any day they're told to, because it's the military. And she kind of just ignored that. And because they give the states discretion to get the ballots there, to require the ballots to get there from overseas and from the military a few days early, it doesn't mean that they have the right to set a deadline past Election Day. A deadline which she doesn't tell us what the final deadline should be, what the outer limits of it would be. Under Justice Barrett's analysis, there doesn't even have to be a deadline. There could be a practical one, but I don't even know if it's practical. She suggests that, well, the electors vote for the president in early December. Well, why does that have to? Well, maybe they keep the ballots coming in till then. Why? Maybe they want to game the system, and maybe a state wants to game the system and just wants to keep it open through January 6th, or even beyond then. Same with congressional ballots. Why does the deadline have to be before the new Congress is seated? Why not just keep it open there forever until the next election? As long as the ballots supposedly are mailed on Election Day, there doesn't have to be a deadline as to when they're received. Do you think that comports with a federal law that sets an election day? I don't, and 4 justices of the Supreme Court don't. And so I'll go through a little bit of, well, a lot of what Justice Alito wrote in response to this majority opinion, which eviscerates Election Day. So let me bring it down. You can read a little bit, watch me read, so this is going to be a little bit of reading. But, it's important. I know we're not allowed to talk about important things in this culture for longer than a minute, but I'm going to do it here. Plus, we've worked for years on this. As the court explains, an election is the expression of the electorate's choice. But because the electorate is a collective body consisting of many individuals, the way in which it expresses its choice is less straightforward than would be the case if the electorate were a single individual. If the electorate were an individual, it could issue a document declaring that specified men and women were selected to fill the federal offices for which the candidates had competed. But because the electorate is a collective body, it cannot express its selections in that way. Instead, its choices are embodied in the collection of ballots cast by the individuals who make up the electorate. Taken all together, this collection is the equivalent of a single document declaring the winner of each race. The expression of the electorate's choices is conveyed to the responsible election officials when the collection of individual ballots is completed. At that point, the electorate authoritatively expresses its choices, and what the Election Day statutes demand is that this authoritative choice be made on Election Day. If ballots received after Election Day are added to the set of ballots that dictate the election's outcome, the electorate's choice does not occur on Election Day, and the federal Election Day statutes are violated. In this case, we must apply this interpretation of the federal Election Day statutes to a Mississippi law that requires state election officials to accept ballots that arrive for up to 5 days after Election Day. The acceptance of these late arriving ballots effectively postpones the date on which the electorate's choice is made, and federal law precludes the postponement. For this reason, I would affirm the decision below, which held that the provision of Mississippi law requiring acceptance of late ballots violates federal law. Because the court reverses the decision based on flawed understanding of the Election Day statutes, I respectfully dissent. Now, Justice Alito was joined in this dissent by Justices Gorsuch, Justice Thomas, and Justice Kavanaugh, at least in part. Justice Kavanaugh didn't sign on to Alito, went off a little bit at the end, quite correctly in my view, in terms of highlighting the unanswered questions or questions raised by the decision of the majority. But Kavanaugh agreed that Election Day is Election Day. So where else do I want to read from in this excellent decision by Justice Kavanaugh, which I encourage you to read in its entirety? Today, not all voting occurs in person on Election Day. Both voting by mail and early voting have become popular, and respondents do not dispute the lawfulness of these modern practices, nor do I. But acceptance of these practices cannot change the fact that under federal law, the electorate's collective choice must still be authoritatively expressed on Election Day. And down this page here, Election Day is a specified date, not a span of multiple days. The Election Day statutes require that federal elections occur on that date. And he emphasized on there, you can see. Under the challenged Mississippi law, however, the collection of ballots continues for 5 more days, and therefore the election is not held until the end of that period. How can you argue with that? Because federal law requires that the election occur on Election Day, it preempts Mississippi's statute. This conclusion finds support in legal authorities from the period when the federal Election Day statutes were enacted. Legal dictionaries of the era, this is the dueling dictionaries, described an election as including both the casting and receipt of ballots. So Justice Barrett and her colleagues in the majority said an election occurs when you cast the ballot. Justice Alito says, well, that's not sensible. Your ballot doesn't mean anything until it's received. That's the election. Dropping your ballot in a mailbox is not the same thing as dropping your ballot in a ballot box. Again, dropping your ballot in a mailbox is not the same thing as dropping your ballot in a ballot box. The ballot box is maintained by the officials of the election. Only when the ballot is, whether it be mailed or otherwise, is received, is the vote matter. There's no vote. It's just a piece of paper. Further down in the dissent by Justice Alito, he highlights the history of the Civil War, and he's using Judicial Watch's historical research here. And the Civil War was the first time, more or less, that we had mail-in balloting, where ballots were being collected on the battlefield, et cetera. And here's what, Judicial Watch explained all of this history in our briefs, and Justice Alito brings it forward in his dissent. Before the Civil War, nearly all voting occurred in person at polling places, so Election Day was ipso facto the day on which poll workers collected all the ballots. This practice did not falter when the cannons rang out at Fort Sumter, even when the Civil War took soldiers hundreds of miles from their usual polling places. Election Day still meant ballot collection day. States took different approaches to ensure their soldiers could vote while away from home. Some states allowed soldiers to mail their ballots back home, either directly to local officials or to proxies who would cast them at the polls. Others sent commissioners to soldiers' camps to distribute absentee ballots, collect them, and then deliver them to officials and soldiers in each soldier's hometown. A third group of states tasked military officers with administering polling places in the field, complete with ballot boxes and voter registration lists. On this model, officers collected ballots, checked names off lists, counted votes, and for some states even took oaths as election officials. Critically, regardless of the method a state used, each state continued to mandate that poll workers, whether on the field or back home, receive soldiers' ballots by election day. So the point being, during the Civil War, we were risking our lives, the collective we, to make sure that soldiers could vote away from home, not any day, but by election day. The majority's argument, therefore, boils down to this: states complied with what they understood the federal election day statutes to require. They did not believe that those laws required that ballots be received by election day, but they nevertheless eschewed the freedom they had asserted before 1845 and voluntarily imposed extraordinary burdens on soldiers and election officials during the Civil War to ensure that ballots were received by the federally imposed election day. And they did all of this, the majority speculates, because, quote, extending the deadline for the receipt of ballots might not have occurred to them. To say that this is not the most likely explanation of the state's thought processes would be delicately put understatement. The notion that extending ballot receipt deadlines for soldiers might not have occurred to the minds of legislators during the Civil War is hard to take seriously. So Alito's really punching hard here. So let's go towards the end of the dissent. And here I'm going to read a bit of a lengthy section because I think it's important. Because this is like, and this is the part I don't think that Justice Kavanaugh joined in, but we'll see. It's on page 16 of the decision. Not only is today's decision inconsistent with statutory text, legal context, historical practice, and precedent, it also threatens to produce lamentable consequences. The majority's holding spawns a slurry of troubling election law questions and risks further undermining Americans' confidence in election integrity. The majority holds that a state complies with the federal election day statutes if it requires that ballots are postmarked by election day and received within 5 days after. But this simple holding supposedly obfuscates the many unsettling questions that the majority position entails. And then he goes on a list of what about this that is just incredible. For instance, do the federal election day statutes impose any ballot receipt deadlines? Mississippi counts absentee ballots that arrive up to 5 days after the federal election day. But nothing in the majority's opinion turns on that 5-day duration. Indeed, some states will count mail-in ballots that arrive for as late as 21 days after Election Day. That's in Washington State. If the election is complete when voters fill out their ballots and send them on their way, may states eliminate ballot receipt deadlines entirely? It appears that the only federal backstops for ballot receipt are the date when newly elected representatives and senators must report for their swearing in, and the date when presidential electors must cast their votes. As I said earlier, I don't even know if that's true under the logic of the majority opinion. Next, would it suffice under federal law if a state authorized voters to tender their ballots to any third party by election day? And what he's saying there is that in Mississippi, they say if you give your vote to a postal employee, you drop it in the mailbox, that's your vote's cast. And what Justice Alito is saying, well, why limit it to postal workers? What about Judicial Watch staffers or union members or your neighbor or whoever, candidates? Mississippi counts late arriving absentee ballots only if they are sent using the Postal Service as a common carrier, but nothing in the Election Day statutes gives those entities special treatment. Could a state, therefore, count late arriving ballots if they are delivered by some other intermediary? How about a relative of the voter, a helpful neighbor, an Uber driver who agrees to serve as a courier, a ballot harvester affiliated with a political party or interest group? May states use something other than a ballot's postmark to determine when someone voted? Mississippi requires that an absentee ballot be postmarked on or before Election Day. Other states don't. Illinois doesn't. I don't think California does, too, in certain circumstances. Do these state laws comply with the Election Day statutes? What happens if a voter deposits a ballot in a U.S. mailbox on Election Day after the last mail pickup for the day? What happens if a courier offers a recall service? The majority's rule apparently rests on the notion that a voter has made a final selection of an office holder once the voter tenders a ballot to the party who will deliver it. But the Postal Service allows its customers to recall mail mid-transit, as do many private parcel services. Now, we highlighted that, we uncovered that and presented it to the court, and the Supreme Court just poo-pooed it. Given that fact, is a voter's selection truly final when he or she puts a ballot in the mailbox? The majority dodges the question, offering the passing suggestion that Mississippi's statute would be preempted only insofar as it allows voters to recall their ballots. May the Fifth Circuit hold as much on remand? Must state law expressly prohibit voters from using recall services? Do the Postal Service's or FedEx's mail recall policies violate the Election Day statutes as applied to absentee ballots? For state legislatures trying to understand what the Election Day statutes allow, the majority's opinion or decision opens Pandora's box. Finally, today's decision leaves open opportunities for voter fraud and may further undermine Americans' faith in the integrity of the country's elections. Diverse sources have recognized that mail-in ballots increase the potential for fraud. In 2005, a committee chaired by former President Jimmy Carter and former Secretary of State James Baker, who's a Republican, found that absentee ballot voting was, quote, the largest source of potential voter fraud, unquote, in American elections. Justice Stevens, a famous liberal Supreme Court justice, recognized that the risk of voter fraud perpetrated using absentee ballots is real and could affect the outcome of a close election. Some amici in that case similarly explain that when voter fraud occurs these days, it generally takes the form of organized fraud, such as the use of fraudulent absentee or mail-in ballots. And it stands to reason, because mail-in ballots are, the voters are necessarily filling them out away from any official. It's unsupervised voting. So no one's seeing if there's any intimidation or improper collections and pressure or fraud and other things that you would be able to see better if the election, if the ballots were being cast in person at a polling place. It's not difficult to understand why. When someone votes by mail, it is harder for officials to verify the identity of the person requesting and completing the ballot. Mail voting also presents a greater opportunity for voter manipulation, a more vulnerable chain of ballot custody, and a diminished ability to detect improprieties in real time. Today's decision compounds those vulnerabilities, allowing absentee ballots to pour in over the days and weeks after Election Day, by which point preliminary election returns are being publicly reported, creates greater opportunity for fraud and risks further undermining the public's confidence in election integrity. As Justice Kavanaugh has explained, When thousands of absentee ballots flow in after Election Day and potentially flip the result of an election, charges of a rigged election can explode. Likewise, it is not difficult to foresee the types of fraught situations that the counting of late mail-in ballots may lead to. Suppose that the outcome of a close presidential election hangs on the final vote in a state that allows officials to count mail-in ballots received up until 2 days before its presidential electors must meet to submit their votes. And suppose that when the ballots cast in person are counted by the morning of the election, by the morning after the election, one of the candidates is ahead by 15,000 votes. As the mail-in ballots arrive and are counted, that lead alternatingly dwindles and swells. By Thanksgiving, the lead of the candidate who has been ahead since Election Day dips to just 1,500 votes. This figure holds until a few days before the state's electors need to vote, when one last tranche of mail-in ballots puts the opposing candidate in the lead by, say, 87 votes. It's not pleasant to imagine what this course of events would mean for the popular faith in the integrity of that election and our electoral process in general. Even in the absence of partisan rhetoric, drawn-out ballot counting induces a large, significant decrease in American trust in the elections. By allowing states to continue receiving new ballots during these drawn-out processes, today's decision will only exacerbate. By allowing states to continue receiving new ballots during these drawn-out processes, today's decision will only exacerbate voters' distrust. I mean, look at what's been going on in California. I was thinking California was going to, make our case with the delayed vote counting as a result, in part, of late election ballot arrivals. In response to these concerns, the majority counters that the appearance of fraud could persist under respondents' interpretation of the statute. But that contention is as non-responsive as it is unremarkable. No statutory scheme will eliminate concerns about fraud entirely, and nobody claims that an Election Day ballot receipt deadline would do so. Nevertheless, as the majority acknowledges, election timing laws are one tool that governments have traditionally used to reduce opportunities for voter fraud. Indeed, concerns about fraud were a leading cause of the enactment of the federal Election Day statutes at issue in this case. It is undeniable that a prohibition on counting late arriving ballots would provide an additional hurdle for bad actors seeking to stuff ballot boxes when early election results suggest a tight race. The majority incorrectly removes this safeguard from federal law. Today's decision is inconsistent with the terms of the Election Day statutes, contemporary election law principles, 2 centuries of historical practice, and the case law on the question presented. It opens up and fails to resolve a host of questions for state election officials and courts, and it creates a serious risk of further undermining public confidence in our elections and our system of self-government. I therefore respectfully dissent. So what do you think? I found obviously I found Justice Alito's decision or dissent persuasive. I did not find persuasive or even serious Justice Barrett's opinion, joined by Chief Justice Roberts and Justice Kagan, Justice Sotomayor, and Justice Jackson. And where does that put us now? It puts us in 2 situations. As Justice Alito points out, it puts us in 2 scenarios, or gives us 2 scenarios going forward. We can try to litigate some of the issues that Justice Alito suggests might be able to be litigated, because it raises a host of questions about what counts as casting your ballot by Election Day. Is there proof required? Are there limits to the deadlines? Can it be 21 days, 30 days, 60 days, months? So Judicial Watch, of course, will continue to explore that area as invited to by Justice Alito, because we have active cases on these Election Day statutes. So we're going to have to figure out how to either Do we have to dismiss the cases completely because this was, you know, the court said that the states can set the deadlines. But there are other aspects that can be challenged still. We'll have to figure that out. Our legal team will. And the other big issue, and Justice Barrett made this clear at the end of her decision, this is not a constitutional rule. This is a statute created by Congress. And if Congress doesn't like the statute as it's being applied here, they can clarify it by changing the law to make sure that, yes, election day means election day. You got to get the ballots done in there by then in order for them to be counted. So that's now up to Congress. And of course, the states individually can make this decision as well. Check to see if your state allows the counting of ballots that arrive late. You may think they don't, but they probably do for military ballots and overseas ballots. Late counting of ballots, no matter the origin, undermines election confidence and invites fraud. Under this Supreme Court decision, the counting of late ballots is not illegal, although we think it properly interpreted, the law makes it clear that they are illegal. But it should be stopped. So there are a lot of states that are supposedly red that think they're doing people a favor by extending a deadline for no good reason for people who are living overseas or the military. And the military can get their ballots in on time. You tell them to get it in by day whatever, they'll get them in. The military is set up very well for doing that. And if you're living overseas, I mean, that's an area ripe for abuse. And then the least you got to get your ballots in on time. And states can change their own laws in that regard. Now, is California going to all of a sudden change its law saying that you got to get your ballots there on time? No. Is Illinois? No. Is New York? No. Is D.C.? No. Congress can force D.C. to. Why? Of course, Justice Alito gets at this, but I'll be more direct. The reason that these states recently, this is a new thing, because the states for centuries, practically speaking, have followed the rule of election day. And the reason they've changed the rules recently is to make it easier to commit fraud and steal elections. I don't think there's any other credible reason for it. It's absurd. So Congress can change the law. Judicial Watch can continue to litigate around the edges here. Who knows? Maybe we get it back to the Supreme Court and they change their mind. And the other thing we can do, which we're already doing, Judicial Watch is already doing, is that, look, mail-in balloting is the problem here. Right? If there wasn't mass mail-in balloting, it wouldn't be an issue with ballots getting there late because you have to vote in person. And that was President Trump's response. He's like, we got to stop mail-in balloting, except for some categories of people. And he was frankly too generous he was more generous than I would be. I'd narrow it much further than he'd be willing to narrow it. So that's one really easy way. And the way to do that, because mail-in balloting would be prohibited under the Save America Act, is to get the Save America Act law passed. So if you don't like this decision and you want to mitigate the damage it does to election integrity, limit mail-in voting, which is being done, I'm pretty sure, that's one of the reasons the left hates it, under the Save America Act. Call your senators, 202-224-3121. Call your members of Congress, 202-224-3121. It's not too late. They can get it passed, change the rules, and protect our elections. The other thing that can be done, which Judicial Watch is already doing, is if they're mailing, if there are, in the case of California, sending ballots out to people who don't even ask for them, as long as they're, quote, on the voting rolls, is to make sure the voting rolls are clean. Judicial Watch litigation and legal action has caused the removal of 6 million dirty names from the voter rolls. Those are 6 million fewer opportunities for voter fraud under this mail-in ballot regime that the left is now enamored with. In California, we just sued to remove nearly 900,000 more names. I tell you, if there's a list of names that California knows is dirty, meaning that they haven't voted forever, and then that list, you've got to not be voting for a long period of time before you get on it. It means that there are people who are moving who don't make it onto that list for years who are still getting ballots. So you've got to stop the mail-in balloting, and you've got to make sure the voting lists are clean. Now, Judicial Watch is making sure, as best as we're able, the voting rolls are clean. We've removed 6 million. If we win in California, or hopefully they settle the case, it's like Oregon settled with us, they're removing now 800,000 names. So that's 7 million if we win in California, or California agrees with us. But there are at least 24 million nationwide that need to be cleaned up. So if Election Day has been defined away in a significant way, the way to deal with it is to change it to make sure it means what it says, what I think it's clear it means on its face, but clarify, Election Day means you need to get the ballots there on time, on Election Day, or by Election Day. Prohibit mail-in balloting, and in the least, as Judicial Watch is doing, make sure the states are taking reasonable steps to clean up the rolls so that people who are dead or moved away aren't having ballots mailed to them or given or providing a pool of names from which fraudsters can use to send in illegal and fraudulent mail-in balloting. So, I mean, we lost this case. Now, we won another big case earlier this year, as I said, with the Congressman Boss case, a huge case, which could be potentially as important in the sense that because of that case, candidates now have an easier chance or basically the opportunity, much more significantly, to go into court and sue to stop dirty elections or dirty election practices. So in this past Supreme Court term, Judicial Watch won one, we lost one. And, you know, and I think in losing this case, I think there's a silver lining in that the American people are further educated about the fact that there are states that count ballots that arrive late. California highlighted it dramatically. It's going to happen again, where we probably won't know who controls Congress until weeks later. I shouldn't say probably. It's a good likelihood. I mean, in California, there were 2 members of the California Democrat delegation now, 2 members of Congress, Democrats, who were losing on Election Day, and they, quote, won as a result of the arrival of election ballots that were late. I mean, and that's why I say, if this continues to happen, our elections are going to be just further undermined in dramatic ways. So I wish the Supreme Court had gotten it right. We tried. I don't, you know, after reading the decision, you can read it yourself. I don't know how many more arguments we could have made. The Chief and Justice Barrett and liberals had zero interest in buying into them, and we're going to reject them. But in the end, Congress can change it, and we can take steps to mitigate it which we have been already doing because of the mass mail-in balloting nightmare that's been going on, in terms of cleaning up the rolls and still trying to affirm Election Day as best as we're able under this terrible decision. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.